Today, I want to convince you that both of those are failures of leadership and that there's a third way that's far more powerful. So pause and let's hang out with that thought, that idea. Um, but I just want to say I got started about a minute late, and I'm sorry about that to anybody who was prepped to tune in promptly at 3 o'clock. We've got some serious summer thunderstorms rolling through today. So if you hear the occasional crash of thunder, um, sorry about that, but I guess we'll just call it atmospheric and leave it there. So I had some technical difficulties, and now we're off to the races. The law is it's not a fence around a leader; it's the foundation under a good one. And the leaders who understand that stop leading from fear and start leading from a place of greater freedom. When you treat the law as a fence, every question you ask is a question about permission. What can I do? Can we do this? Are we allowed to do that? What am I allowed to do? How much can I get away with? Where's the line? That's a kind of small and anxious way to lead. And your people, the ones that rely on you and look to you for leadership, they feel that. But a foundation poses a different question. If we look at the law as a foundation, our starting assumption is different. You don't resent the foundation of your house for limiting where you can put the walls. The foundation is the reason that the house stands at all. It's what lets you build that second story or third story. Legal structure works the same way in a business. A clean entity, a well written operating agreement or bylaws or partnership agreement, contracts that actually say what everyone believes, where the words on the page match the reality of what's happening, the transaction. All of these are not restraints on your ambition. They're the load bearing walls that let your ambition go higher without the whole thing collapsing. The leader who understands this stops asking, "What am I allowed to do?" and starts asking, "What structure lets me do the thing that I'm actually called to do, that I actually want to do? What is the ideal structure that moves things forward, that's congruous, that's consistent with the vision that I have?" I feel like a story could best present this idea. So I'll tell you one of my absolute favorite stories from law school. It's about a case called Summers v. Dooley. Summers v. Dooley is a partnership law case, and it was about two guys that wanted to start a trash collection business. Could not be simpler. They got a truck. They're going to drive around, pick up trash, haul it off, and split the money, split the costs, split the profits, everything split 50-50 right down the middle. Well, Mr. Dooley wanted to hire a third man and pay him out of the partnership funds. And Summers said no, because that would have been less money out of his pocket. He was content to work a little harder or whatever, or just be satisfied with the way the business was, the status quo. So he said, "No, I don't want to do this." Mr. Dooley said, "Well, you don't have any more authority in this business than me. Who are you to tell me no?" Essentially. And he went and hired the third man anyway, paid him out of the partnership funds. And this created a problem, a lawsuit. And Mr. Summers sued Mr. Dooley, hence Summers v. Dooley. And the court said that in the absence of a written partnership agreement that talks about how these kinds of disputes can be resolved and has a mechanism for resolving them, in a 50-50 partnership, the dissenting partner, the one who says no, always gets their way. This has been partnership law forever, and it's for a good reason. You had an agreement. You agreed about the way things would be in your business. You agreed to equally share authority. You agreed about the way that things are. and you can't change that on your own. You have to agree to change that or agree to end that. So one person can't unilaterally on their own change the agreement. You're stuck with what you agreed to. I have, over the last 14 years of legal practice, helped lots of people get their business started. It's one of the things that I do. In fact, I do it pretty well, and I wrote a book called How to Structure Your Business for Success. And now I've started including all of our business formation legal services in our profit from legal service, our fractional chief legal officer service. So if you're wanting to start a business and create it the right way and have support all the way along, we'll do your business formation work at no additional charge. We just include that with the, legal advice and legal support service that we offer. And we'll also review your foundational documents, your formation documents, when you start the service, and we do all that at no additional charge, clean it up, get it right. And over 14 years, I've seen lots of people that want to start 50-50 partnerships. And I always tell them the Summers v. Dooley case story. I say the court said that the dissenting partner always gets their way. So what happens if you have two people with equal authority who equally disagree? Well, nothing happens. What happens in that situation? Nothing happens. It's status quo. It's stagnation. It's deadlock. So if you're going to have a 50-50 partnership, you need to have an agreement that defines the relationship, who's in charge of what, spheres of influence, zones of control, allocation of authority, division of labor, that sort of thing. Who, yes, you're 50-50 partners, but which half? Which half do you get? What are you in charge of? And what do you get to make decisions about that the other person doesn't, and vice versa? What decisions do you have to make together? Let's get it in writing. Let's put it in a partnership agreement. And for those things that have to be decided together, let's have a mechanism for how to resolve the situation when you have two people who have equal authority that equally disagree. I don't care if you shake a magic 8 ball, flip a coin, do what you got to do. Lots of people go to a third party and say, this person's that we've designated or that we agree on will be the tiebreaker, someone that they both respect and they both trust. And that's a pretty simple example of the kinds of things I'm talking about it when it comes to legal structure. It's a very common sense example. It's accessible, it's easy. It might even seem obvious to you. But there are lots of situations that are more complex, that are no less uh, important to document properly. I've seen lots of people who've over the years told me, well, that's what the contract says. That's what it says on paper. But every time I hear that's what's on paper, but my brain uh, starts screaming, red alert, red alert. We've got a problem. There should not be any real difference between what's on paper and what is actually happening. Um, so that is a matter of honesty for me. Um, I think a lot of the legal problems that people have don't start out as legal problems per se. They start out as failures of leadership. They start out as sometimes failures of character. And my work in preventive law led me to develop skills advising leaders and being a trusted advisor to leaders, individual leaders and leadership teams. I had a pretty significant couple of setbacks in 2021 where I lost two key supportive relationships in the same month. Um, one due to death and the other due to a relationship change. And they were both of those losses, especially back to back, the way that they were devastating to me. But in the wake of that, sort of rebuilding myself and my life from the ground up, um, I put into practice a lot of the leadership lessons I had been learning in my law practice, along with other things that I was learning at the time about life and myself and all of that. And I wrote a book called Lead Again: A Modern Guide to Resilience. And in that book, I put all the lessons that I use to go from setback to comeback, and it's been very helpful. And in publishing that book, I rebranded my law practice and I started doing resilient leadership coaching. Really, I just formalized the way that I delivered a lot of the leadership coaching work that I was already doing as a lawyer, as a trusted advisor. On the legal side of things, I found a way to take all of those sort of side conversations that weren't really conversations about the law, that were conversations about leadership and how to repair systems and relationships and how to navigate the things that weren't really um, the legal aspect of a relationship, but they were no less a part of the situations that we were working on, right? Whether it's issues with co founders or issues with stakeholders or issues with investors or issues with employees or vendors or whoever, right? There's a leadership component, and then there's the legal component, and the line between those two things is often very blurry. And so I wanted to have a way to really identify and properly charge for both of those types of services. So I have the legal side, I have my rates for that. And then if I do leadership coaching and the client wants that, then that's, billed separately and discreetly. And there's a plan and, there's a whole method to it. And the method is largely built on my book. Um, but I think it's important for us to acknowledge that when we're talking about legal structure and how we're structuring an entity efficiently, or structuring a relationship, or documenting it in a contract, or resolving a dispute, even that's already arisen, we need to, yes, acknowledge the legal realities and the processes and all of that, but we also have to treat the leadership issues, which are more general and human, and they're not, strictly speaking, things that the law always cleanly recognizes or has a solution for. They are almost always down to um, interpersonal skills, social skills, and um, character. So there's this old idea that good character comes down to four habits. And I think that the practice of law, done honestly, trains every single one of these habits. The law, well observed, is a great foundation for a leader. Put another way, if a leader doesn't lead from fear, and if they don't take that small-minded approach to the law, if they really embrace the structure of their leadership and the structure of their business along like legal lines and principles, down to the old equity maxims, I would say, uh, then they'll get a pretty good crash course in leadership. Like if you understand what the law says about how you're supposed to govern your business, um, if you do it the right way legally, then you'll be doing a lot of things right from a leadership standpoint. It won't tell you, the law doesn't tell you everything about how to build a good corporate culture. It doesn't say everything about everything, right? But it gives you the basics. Again, these four habits of character um, are trained through the practice of law as applied to business. And here are the habits. Prudence, right? Prudence number one. It's the habit of seeing consequences before they arrive, you know? It's the entire discipline of a good lawyer, being able to forecast risk and have a plan for how to manage it. It's the first thing that separates a leader from a gambler. The gambler might not be prudent, but a good leader is. The second is justice, giving each party what they are owed, which is not a sentiment. It's literally the work of a well drafted contract to be just, to be fair, to be equitable. And, you know, a good contract is going to articulate what each person can expect and then hold both of them to those expectations that they've agreed upon and they've stated in advance. Too often we find ourselves going to the courts looking for justice. And the longer I practice law, the more convinced I become that we don't have a justice system. We have a legal system. You get as much justice as you can afford, and it shouldn't be that way. It shouldn't. But I've started to lose faith, really, in the ability to see justice done. I see procedure treated as unimportant. I see lots of people saying that, they're over things like discovery, they're over this procedural rule, that procedural rule. They're not going to enforce it or they're not going to apply it. They're not going to be strict about it. They're going to be cavalier. I had one judge who has now passed away. I won't name him, but uh, he agreed with me in a small claims court case where the plaintiff had entered into a release with the defendant. They had released them from any liability and then 2 months later sued them anyway. And I represented the defendant and uh, well, of course, successfully, I won. I said, well, there's no lawsuit here. I moved for dismissal under Rule 12. And in Tennessee, we have a statute that was passed in 2012 that says that the loser must pay the winner's attorney's fees in a case like that, where it was a frivolous lawsuit. And the judge denied attorney's fees. My client was absolutely entitled to his attorney's fees. It's not discretionary. It doesn't say that the statute doesn't say the judge may award attorney's fees or should or can if he wants to. It says shall. He shall award attorney's fees. And this judge said no. And so I did something that most lawyers would never do, which is I filed a motion for post judgment relief in small claims court, where you don't really file written motions. It's just not done. And I did. I said, you want to try again? Basically, respectfully, Your Honor, you want to try again? And the judge in that hearing on that motion said, I agree with Mr. Bagwell. This is the most egregious case of a frivolous lawsuit I've seen in all my years on the bench. He said this openly. And he said, nevertheless, I've already ruled on attorney's fees. And I'm not going to award these attorney's fees, regardless of what the statute says. He openly and flagrantly declined to follow the law, basically admitting it. And then said, Mr. Bagwell, if you don't like it, that's what attorney's fees. I mean, that's what appeals are for. That's what appeal. Yes, you could go appeal it to the circuit court. So again, this judge is no longer with us. He's not on the bench anymore or anywhere. But you know, he's not alone. He's not the only bad judge in Tennessee. Um, and there are lots of judges all across the state and all across the country that are kind of they're the little barons of their own little hill, and they don't uh, really have meaningful checks against their behavior or their rulings. You know, um, there's not really a meaningful way to remove a bad judge other than to vote them out. And if a judge decides he's not going to follow the law, he may or may not get overturned on an appeal, but appeals are expensive, especially if you get up into the courts of record. It's a very expensive and time consuming to appeal a case. And if you have a bad judge who makes a bad decision, it can be extremely disruptive and devastating. And it's a shame that it's so difficult to find justice in our courts, but it is. It is hard. And so my advice to my clients is don't do that unless you absolutely have to. Don't litigate unless you have to. Do the work on the front end, the preventive work. Stay out of court. Keep your case off their dockets. Do not darken the doors of a courtroom unless you've done everything else you reasonably can do to resolve your disputes. Arbitration, mediation, direct negotiation in good faith, trying to resolve the dispute. Do everything you can to resolve the dispute before going to court, because we do have a legal system. Sometimes it works. And there are good judges out there too. There are some good ones. Absolutely. And I think lots of judges want to do the right thing, but they have a lot of pressures on them from a lot of different um, corners of their life, right? There's the political side of things because they are elected officials, so they have to get reelected if they want to keep their job. They've got to think about that. They've got pressure from the Court of Appeals. They don't want to get overturned on an appeal. They've got to get things off their docket in an efficient way and have cases heard. And then there's the desire to do a good job that some of them have. And it can be very difficult. I'm not saying that judges have an easy job or that there's an easy fix to the solution of some judges not being good at their job, or not following the law. And not everyone is going to see things in a black and white way or be a real stickler for procedure or the rules or whatever. But I literally had a case where a judge, this was much earlier in my practice, um, a judge uh, declined to find in favor of my client, because my client had been charged with disorderly conduct on a school bus. It was a court appointed case, and I was representing a young man. And the disorderly conduct that was alleged was in response to the bus driver who got in this kid's face. He towered over him and was intimidating to him. And the kid went chest to chest with him and yelled in his face or whatever. And they charged him with disorderly conduct, like criminal charges, disorderly conduct. And I said, well, the disorderly conduct statute says that this conduct has to have happened in a public place, but it happened on a school bus. That's not a public place. I can't go on the school bus. That kid's own mother or father could not have gone on that school bus with him without permission from the bus driver, the principal, whoever else, right? Like a public school bus is locked down. It's like a tiny prison on wheels. You can't go on there unless you're supposed to be on there. Um, a public school bus is not a public place. The judge said, "Well, it's paid for with public funds, and it's driving on public roads, and it's very much like a public restroom where I can't." He said, "I can't go in the ladies' restroom. I'm restricted from going in the ladies' restroom. That doesn't mean it's not a public restroom. The ladies are allowed in there, right? A place can be public, but still have restricted access." And he said, "I'm not gonna," he said, to my client, he said, "You should be thankful to Mr. Bagwell. He's been very creative. He's, clearly made the best argument anybody could make here and has, done a good job for you. So it's not his fault that I'm finding against you, but I'm not gonna find in favor. I'm gonna find you guilty of disorderly conduct." And I think he ordered him to do some community service or something like that. It's been years and years. It's been over 10 years, so I can't recall, but um, anyway, I asked the judge, I stayed after court and I said, "Your Honor, respectfully, I don't understand your ruling. Could you help me understand your ruling?" I said, the law says it has to be a public place and you can't just there's no public access. I understand what you said, but do you really think a school bus is a public place?" And he said, "Mr. Bagwell, I'm just not inclined to uh, decide cases on a technicality." He said, "The substance of what your client did violated the spirit, if not the letter of the statute, and so I found against him." He said, I'm not gonna allow a case to be decided on a technicality." And I said, "Well, with respect, Your Honor, if you took away all the technicalities from the practice of the law, do you know what would be left?" And he said, "No, what?" I said, "Journalism. If we take away the logic and the technicalities and the specificity, the accuracy of the law, if we refuse to be technical in our practice of the law, we're just left describing what happened and having opinions about it, that are more or less based on what our read of the situation is and our feelings about that." And I don't think that that's a blindfolded Lady Justice with a sword in one hand and scales in the other. That's not how that seems to me. It's more of a rule of people rather than a rule of law. And that's not what we want. That's not what our system is designed to give. It's not justice. My point here again is justice is giving every party what they're owed, and that can't be a sentiment. It can't be a feeling. It has to be um, clearly cognizable. You have to really understand it. You have to be able to articulate it. You have to spell it out clearly, right? And so we need to do that in our contracts and in our governing documents for corporations and LLCs and partnerships and so on, our vendor relationships. We got to spell all that out, make sure that everybody's clear about it, and then hold people to it, to the technicality, to the comma, to the period, if we must. So that's the second habit. And I think doing that as a good leader basically translates into being unyielding where it's prudent to be unyielding, where it's about doing the right thing, the just thing, the equitable thing, the fair thing, to be unyielding in doing that. I think Lady Justice's sword should be sharp, sharp enough to split a hair. But sadly, we've replaced that sword, that sharp sword, with a dull club, and that's a shame. So, if we can't find that justice in our courts, or if it's hard to find or not reliably found there, try to structure things so that you don't have to go to court to get justice, so that you can structure the incentives between the parties to find justice before you have to go to court. The third habit is fortitude. This is the one that I've seen lacking perhaps more than any other. Fortitude is the courage to make the hard call and then stand behind it. Legal preparation, though, is what makes that courage possible. And I think that's why fortitude is so lacking. I think it's not because people are cowards per se. It's because they haven't done the preparation to really have the courage that if they do the right thing, then they'll get the right result. And people focus so much on getting the result they want that um, they don't really uh, leave themselves the space to get there the right way, ontologically speaking. Um, you're a lot braver when you know exactly where you stand, I think, and especially when you know that you're standing on the side of the angels. When the law is on your side, when ethics is on your side, when you know that and you can see that, when you've done the preparation to be reasonably assured of that, then you say, well, yeah, of course, we don't want to go to court, but if we have to, we can. We absolutely can. And you tell the other side, look, if we go to court, you're going to end up, paying a lot more. That things are not going to go well for you. We have thought about the possibility of this dispute from the moment that we started doing business with you. And we've been prepared from that moment until this one. So if you really want to run afoul of the law and ethics and our contract and our agreement and what's right, if you want to run afoul of all of that, we're prepared to hold you to every comma in this agreement. And then finally, there's temperance, right? Because sometimes it's not the best idea to do that actually in practice, to to allow your courage to take you all the way through a very expensive and long and drawn out process. Temperance is knowing when not to act or when to wait. It might not be the best idea to immediately file um, some paperwork on someone. Just did a consultation with a lady who said that she was in a dispute with a business. And the moment that they believed she breached the contract, they went and filed litigation paperwork. And they didn't give a reasonable amount of time for her to cure the alleged breach. And that ended up coming back to bite them, right? They rushed to incur attorney's fees and all these other fees and costs under the contract. And that ended up costing them. It was a lack of temperance. Sometimes restraint protects more than aggression does. Anyone who's watched a strong case get ruined by, angry emails or, you know, someone losing their head in a mediation, they'll understand temperance. Sometimes you can snatch defeat from the jaws of victory that way. Law practiced well is applied prudence. Leadership practiced well is the same discipline pointed at people instead of documents. They're not two separate subjects, they're one habit of mind applied in different ways. I mentioned that I coach leaders on resilience, and I want to tell you what resilience actually is, because I think that word has been worn smooth by overuse. Leaders don't always break because they face hard things. They break ultimately in many cases because they face hard things unprepared and alone. And legal structure, properly understood, is a form of resilience that you build before you need it. Think about what an operating agreement for an LLC really is, for example. It is a document that you write between the company and its member or members, or and among the members themselves, in preparation for the day that things go wrong. Same with any contract. You sit down in a calm season when everyone still likes each other, and you decide in advance how you will behave when the money gets tight or the partnership fractures, the crisis hits. That is resilience in its truest form. It's not a feeling that you summon under pressure. It's a set of decisions you made ahead of time and committed to honor when the pressure comes. It's just like in a ship where an engineer builds things within tolerances. He understands the tolerances, he understands the strain that that ship will be under, the strain of high winds and high seas, the strain of the pressure of water and the load of the ship's heavy burden. He understands the physical forces that that vessel is subject to, and he builds that vessel to withstand them within certain tolerances. You can do the same thing with relationships, and you can do the same thing with legal fictions, with these constructs, corporations, LLCs, partnerships, etc. The document's just where you write that all down, but you need a professional who understands those things, who understands what could go wrong and how things often do go wrong, both theoretically and practically. And then you need that professional to apply that understanding to your unique set of facts and circumstances, and then write it down the right way. When I was in law school, I remember my first year, I was asking a second year about professors. We were choosing classes for our first year. I'm sorry, our first semester of our second year, we were choosing classes and talking about, which professor's good for this, that, and the other thing. There was one professor that I asked about, and this upperclassman told me a story. He said, if you're going to take that professor, you need to be sure you do the reading, because here's what happened in our class. He said one day, this professor um, asked a girl a question and he stood her up. There's this tradition that you have to stand to answer. Usually, now in modern law school, when you're finished answering the question, you're allowed to remain to sit back down to retake your seat. However, back in the old days, you could stand perhaps the whole hour, and it might just be your day where you're going to get asked all the questions. And then, he'll pick on someone a different day, or he'll choose someone a different day to answer questions. Well, he stood this girl up, and he asked her, a question, and she kind of bumbled through the wrong answer. And then he just turned away from her, like total disregard with his body language, and stood up a different student. And this girl kind of bumbled through the right answer. And instead of praising her for getting it right, he kind of turned and addressed the rest of the class, the whole class more broadly, but kind of still pointedly to the second student. And he said, as a lawyer, you can be two things. You can be accurate and you can be articulate. He said to the second girl, you were one of those things. She was neither. I thought that was just the most brutal, cutting remark. I just thought, wow, that doesn't feel constructive, really. It was embarrassing. It had to have been. But I did take that professor's class, and I was prepared for the readings every single time, and I never forgot that story, and I never forgot the consequences of being unprepared or of failing to be both accurate and articulate. It's important to be both of those things as a lawyer, and you can't be both of those things as a layperson when it comes to legal matters most of the time. And so it's better to consult with someone who knows what they're doing, who went to school for it, and who's licensed to do it in your jurisdiction. I want to leave you with a few questions here at the end about law and leadership. And, you've got a holiday weekend, so maybe you can take some time to think about these things, maybe write down some notes about what you think about it that could help you and serve you. But first, the first question is, what am I building? And does my current structure match that vision? Do you have a clear vision? That's not easy for everybody. Most people kind of know the feeling they want to have. They may not really know what structure matches the goal they're trying to get. They may not even know if the structure they have matches the organizational state they're trying to achieve. So the honest answer for a lot of people here is I don't know. What am I building? I don't know. I know what I'd like to have. I know some things I'd like for it to do, but I don't really know. And I certainly don't know if my structure matches it. That's going to be the honest answer because most people's legal structure fits the business they had 2 years ago, if they've been around that long, not the one they have now. So, this is the structure is something that is alive, it's dynamic, it changes, and it needs to be updated periodically. A good leader will recognize that and engage a lawyer who can advise them on an ongoing basis about how to keep all of that up to date. Second, you should ask, where am I exposed? Here again, a lot of people will honestly answer, I don't know. Is that exposure a decision or an accident? If it's a decision, if it's a well considered decision, you might know, hey, I'm exposed here, but that's okay. I've planned for that. I'm not worried about that. That is um, very much like um, rational ignorance. It's not really ignorance, right? But it's like rational ignorance in the sense that you've decided to intentionally leave yourself open because the practical risk is very low that something bad will happen. Risk is not the enemy always. Unexamined risk is the enemy. A leader is allowed to take risk on purpose. Having the fortitude, having the courage to make the hard decision. Sometimes the hard decision is to be vulnerable in one area or another because you only have so much resources and you have to allocate them wisely. What a leader cannot afford is to be surprised by a risk they never chose manifesting as an immediate problem that needs to be resolved and one that they didn't budget to resolve. That can be disruptive. Third question: who depends on me and have I protected them in writing? In writing, your family, your team, your partners, your clients. Leadership is stewardship, and stewardship that exists only in your good intentions is not stewardship, not real stewardship. It's hope or optimism if it's not well justified. It's not even, might not even be hope, might just be optimism. The law is not the thing that limits your leadership. Handled with wisdom, it is the thing that sets it free. Build the foundation. and then go build something worth the trouble of protecting. I am Noel Bagwell. I'm a lawyer licensed in Tennessee. I'm also a resilient leadership coach. I'm here for you. If you are listening to this, if you have questions, um, this has been open to my subscribers who have had the opportunity to tune in. I sent out notice yesterday that I would be live today and invited subscribers to tune in if they would like and ask questions and have some one on one time. But I understand it's holiday weekend and people probably have other things that they'd rather do. But I hope you found this useful when you got around to listening to it. And if you'd like to reach out to me, you can find me pretty easily online through either LinkedIn or through my website, counselandclarity.com, COUNSELANDCLARITY.com, counselandclarity.com. Um, I'm not a hard guy to get a hold of. So feel free to reach out if you would like some leadership coaching, if you would like legal support for your business, or if you just want a free consultation for either of those things. I'm here to help. And I hope that you will reach out and ask me whatever you'd like to know. Um, Last little thing, lots of people have valid concerns, right? That lawyers are using fear based selling for legal services. I think fear based leadership avoids risk, but what I want to just say that what I'm describing chooses risk deliberately from a position of structure. The point of the foundation is not to keep you safe indoors, it's to let you build higher than the person who has no foundation. Um, Lots of people also over the years have mentioned that they're a very small operation. They don't know really where to start. I always say start with the entity and the operating agreement or partnership agreement or charter and bylaws. They govern everything downstream, and then focus on your client and vendor contracts, your employment agreements. You don't need everything at once. You need load bearing walls first. So get the basics but also get advice, get ongoing legal support, practice having the relationship with the lawyer and using it regularly. Um, you don't have to necessarily even balance a legal caution with moving fast. You sequence those things. You do the structural thinking in the calm season so that in the fast season you can move without having to stop to think. It's almost automatic because it's built into the flow that you've prepared. Preparation is what buys you speed. And the last thing that I've been asked a lot about lately is AI. So lots of leaders are adopting AI tools with no structure around data, liability, authorship. I think this is the fence versus foundation problem arriving in a brand new form. Have good governance, make it well considered and well thought out for your industry and your business. The leaders who build the governance first will be the ones who can move fast with these tools in a way that is safe and good for growth. So, those are four little concerns that I often hear, sort of, you know, frequently addressed issues, if you will. And I just want to leave you with that. I always try to build as much value into these talks as I can, because that's what it's for. It's kind of a almost like a mini workshop or course jammed into 45 minutes. So hope you found it useful. Reach out if you have questions. You can schedule a free consultation anytime. I'm always here for that. And would love to have your feedback in the form of comments or likes or whatever you'd like to leave. Thanks a lot for tuning in. Have a great day. Happy 4th of July. It is America's 250th birthday, kind of, at least the 250th celebration of the Declaration of Independence. So that's pretty exciting. Just be safe out there, you guys. Be safe and smart. Um, and God bless you, and may God bless the United States of America. Thank you.